This afternoon on Mr. Burns' request for a new trial that has been resisted by the state. Also scheduled for hearing this afternoon is sentencing upon the jury's February 24 guilty verdict finding Mr. Burns guilty of murder in the first degree. So that our record is clear, the court, pursuant to direction from the Iowa Supreme Court, has taken steps to severely limit the population who is present in the courtroom today for these hearings. Pursuant to that direction, the very close members of the Burns family and close family friends from Michelle Martinko's family have been permitted the ability to be personally present for today's hearing, and there are members of the media here as well. The proceedings have been made available through a series of websites. There has been a live stream. Permission was granted to the media to live stream these proceedings, so it is available to members of the public, and anyone who cares to observe these proceedings is able to do that by way of that live stream connection. In preparation for today's hearing, I have reviewed the motion for new trial filed by Jerry Burns. And I guess before we get started with that, I will state on the record that Jerry Lynn Burns is personally present this afternoon with his attorney, Leon Spies. Morgan Aber is also here as an assistant to Mr. Spies. The state is represented by First Assistant Lynn County Attorney Nicholas Maybanks. Assistant Lynn County Attorney Michael Harris is here, as is Investigator Matthew Denlinger. In preparation for this afternoon's hearings, I have reviewed the motion for new trial filed by Jerry Burns on May 29th of 2020. His supplemental motion for new trial filed August 5th of 2020, and also the state's resistance filed on June 17, 2020. The court has also reviewed the briefs and memorandum in support of the motion as well as the resistance in preparation for today's hearing. And we will begin with any statements or argument in support of the motion for new trial and the resistance. Mr. Spies, if you wish to give oral argument, you may at this time.
Thank you, Your Honor. And as instructed by the court, I'll remain seated. Typically, on a day like today, I would wish the court a good afternoon. It's not a good afternoon. Mr. Burns is appearing before you today in urging the court to grant him a new trial. And I will not regurgitate what I've expressed to the court in my written memorandum, but I did want to address a couple of matters that were either brought to the defendant's attention in the response by the government, or to elucidate on some matters that I didn't fully brief in my memorandum. First of all, as the court recalls, I moved for a mistrial during the testimony of state's rebuttal witness Paul Bush. Mr. Bush testified in response to defensive evidence about the scientific conclusions to be drawn from the DNA present at the crime scene attributed to Mr. Burns. During the course of that rebuttal testimony, Mr. Bush was asked by government's counsel to explain the presence of the defendant's blood on Michelle Martinko's dress. In its response to the government's to the defendant's motion for new trial, it was characterized that this statement was a hypothetical. I didn't perceive it as a hypothetical. I didn't, in recalling from my notes, that it was presented as a hypothetical question, but rather as a statement of fact. And of course, the defendant objected to that. There was some discussion with the court about whether or not the use of the term blood mischaracterized the evidence. I think you concluded that it did mischaracterize the evidence. And we disputed during the course of Dr. Spence's testimony that it was blood, that it didn't have the attributes of blood, and so forth. So this comment, coming as it did during rebuttal testimony at kind of the apex of the trial, we believe was in a position that it not only mischaracterized the evidence, but caused an introduction of an issue, an introduction of a factual issue that could not be dispelled by the court's cautionary instructions. And I grant that the law in Iowa is that the jury is presumed to listen to and abide by the cautionary instructions. But we believe at this point that the bell had been rung and couldn't be unrung, and that accordingly, the court should have granted our motion for mistrial. The next matter I wanted to address was our claim in our motion for new trial that false evidence, false testimony was presented by state's witness Michael Allison, and that under the prevailing law dealing with the receipt of false or perjured testimony, that Mr. Burns should be granted a new trial. There's a claim in the response to the motion for mistrial, or the motion for a new trial, that there was no false testimony. But I think that the court can readily discern from the record that we've made in support of our motion that Mr. Allison falsely testified that his lawyer, who was an experienced criminal defense lawyer and the assistant United States attorney handling his serious federal criminal prosecution, had made mistakes about the statutory and rule penalties that he was facing. That was plainly false. There was no indication in the hearing transcript that we've offered in evidence in support of our motion that there was any mistake made by experienced lawyers about the penalty that he was facing. Both Mr. Allison and the federal judge were commending the defense lawyer for being compassionate and experienced. Judge Reed acknowledged Mr. Nathan, the defense lawyer in that case, was a very good lawyer. So Mr. Allison's testimony at Mr. Burns's trial, that the reason that the plea agreement in his case was scuttled was because his lawyers were mistaken about the penalties, which is plainly false. He also testified during the trial in front of Mr. Burns that the judge did not reject the plea agreement, when plainly the transcript in his hearing demonstrated that she did explicitly reject the plea agreement. That testimony was false. He also testified that she had asked him, that she, the federal judge, had asked Mr. Allison if he wanted to keep it, and he told her no and left it up to him. Well, first of all, if the plea agreement was defective because it was wrong, she wouldn't have given him the option to accept it. So that testimony was false. He also said that she preferred that he not keep the deal. That plainly was not a matter of evidence in the transcript that we've submitted. So these lies by Mr. Allison were critical. And why were they critical? Because they went to his credibility. They went to his appreciation for the stature of this court. It went to the appreciation for his stature, his understanding of the stature of the federal court. He lied about it, and the lies were material. Now, the government contends that these misrepresentations, if they were misrepresentations or lies, were not material. Well, the credibility of a witness, especially the credibility of this witness, was extremely important to the government's case. And the credibility of any witness, and more importantly, what the state knew about the credibility of that witness, is of constitutional significance. It is plain that the prosecution in Mr. Burns's case, in any case, has an obligation of providing Mr. Burns with exculpatory evidence, including evidence that would tend to impeach or challenge the credibility of a state's witness. We believe that experienced lawyers in this case would have been informed by the Assistant United States Attorney, by Mr. Allison's attorney, about the true texture of the legal position he was in federal court, and that failing to correct the falsehoods that I've just enumerated represented a denial of Mr. Burns's right to a fair trial. The next matter I'd like to address briefly is our claim that there is newly discovered evidence that, if brought to the attention of the jury, would have a probable impact on the verdict in this case. The evidence comes from a woman who, in 1979, recalls that she was providing Michelle Martinko with music lessons or organ lessons at a studio in the Westdale Mall, that she had a regularly scheduled lesson on the night of her murder. She attended that lesson, and after attending that lesson, when the witness believed that someone may have been waiting for her out in the hallway of the mall, left the music studio carrying 2 music books and an assignment book. These music books and assignment book were never located at the crime scene. Why do we think that this is material? Well, first of all, as we've argued in our motion, we believe that this evidence, had it been presented to the jury, would have demonstrated that there were actions that Ms. Martinko took the night of her death different than those described by the witnesses brought by the prosecution. Furthermore, because these music books and this assignment book were never located, never seen in the car, never seen in the parking lot that was examined by investigators, that the whereabouts of the attack that Ms. Martinko sustained may have been someplace other than at the car. The fatal wounds obviously were inflicted there, but she may have been assaulted, abducted someplace else. So we believe this evidence is germane, it's important, and had it been brought to the jury's attention, it would have cast doubt on the theory of the government that Mr. Burns traveled from Manchester, Iowa, or from Elkader, Iowa, drove to the Westdale Mall, armed with rubber gloves and a knife, and inflicted the fatal injuries on someone he had no knowledge of. More importantly, we think that this evidence would demonstrate that someone knew about the regularly scheduled music lessons that Ms. Martinko took, knew her actions, knew her routine, and was able to wait for her that night. So for those reasons, Your Honor, and those voiced in our motion and more particularly described in our memorandum, we urge this court to find that error has been committed. Now, we've also, of course, urged the court to re-examine its ruling upon our motion to suppress, and a full record was made in that respect, and I'm not going to recap our arguments in support of that. Finally, given the unusual nature of the evidence here, we're asking the court to find that the greater weight, the weight of the evidence in this case, preponderates significantly against a finding of guilt, and that as a matter of justice, as a matter of fairness, you should find that the evidence is not sufficient to warrant a finding of guilt and a sentence to be imposed against Mr. Burns. Thank you.
Thank you, Mr. Steves. Mr. Maybank's argument in support of the state's resistance to the motion for new trial.
Yes, thank you, Your Honor. And can you hear me okay? All right, good. Well, unless the court wants to or has questions or concerns about any of the issues that Mr. Spies didn't discuss that he brought up, the state would rely on its arguments that it set forth in the written brief for those matters, but would be happy to entertain any questions the court may have about the state's position on that. We believe our positions were made fairly clear on those other items. So I'll just take a little bit of time to address what Mr. Spies brought up here verbally today regarding what I counted was 4 areas that he focused on. First, the motion for a mistrial that was made during the state's rebuttal case involving witness Paul Bush. At the time that question was made, the state believes the record would reflect that Mr. Bush was being called for a proper rebuttal purpose, in that Dr. Michael Spence had just testified for the defense on various ways or hypothetical ways that the DNA of Mr. Burns could have been secondarily transferred to the crime scene, specifically Ms. Martinko's dress and the gear shift selector. So in laying out not only the hypothetical supported by the evidence in the case that was also supported by not only the state's witnesses, but Dr. Pence himself, when he said the most likely scenario would be direct transfer, the state was also addressing a reoccurring theme that the defendant had brought up during the course of this case, that the source of the biologic DNA that was present at the crime scene, that other sources other than blood could not be ruled out. So the state was addressing that squarely by pointing out, as the evidence did support, that the only substance that tested positive in that biologic specimen that can be confirmed to be present was blood. So in that sense, when the state did indicate Mr. Burns' blood in that hypothetical was not a misstatement or mischaracterization of the record. I don't believe that's what the court found when it admonished, because the objection was ultimately overruled. But if that was the finding, or if the court would revisit that finding, the state would understand that. Although we don't concede it was a mischaracterization, we believe that it was proper for us to pose a hypothetical in response to the defense expert witness, that it was based upon not only direct testimony in the evidence of the presumptive test of the biologic material being positive for blood, but also supported by the evidence as a whole in the record, a scenario that was set forth in that proper hypothetical question. Basically, Your Honor, the defendant was allowed to pose several questions that supported his interpretation of the physical evidence in this case to Dr. Pence and to numerous state witnesses. The state merely took the evidence that was supported in the record and posed a hypothetical to Mr. Bush under those circumstances. Whether you want to call it a hypothetical question or not, that was the spirit and nature of the testimony. In any event, the court clearly took action to address the concerns that Mr. Spies had and instructed the jury on what the evidence did show at that time, which was brought out by the state in the defense, not only during the trial, but during closing arguments, that, yeah, other specimens couldn't be ruled out as being a source of the biologic DNA, but the evidence supported the fact that it was blood. And that's what the state was fairly allowed to argue. And under the circumstances, the court did tell the jury that. It was reiterated. So in that sense, there was no shocking revelation in this question, that the state believed that the biologic evidence at the crime scene containing the defendant's DNA was blood. That was the theory all along. There wasn't a bell that could be unrun. It was something that was very well known. And in that sense, it was addressed by the court. It wasn't improper to begin with, and it was addressed by the court. So we ask that the court find that at least the defense motion for mistrial on that ground be overruled. Second, with regard to Mr. Allison, it took the state a little bit of time to figure out exactly what the defendant was claiming and that Mr. Allison said while he testified that was false. But I think that we did, and it was reiterated by Mr. Spies today, at least what they claimed that he said in this case that was false. And I think that was just an indication of how unclear it was that Mr. Allison said anything false. To support the defendant's argument that prosecutorial misconduct took place, the court would first need to find that there was a false statement made. In support of that contention, the defense found and presented to the court a transcript from a hearing that took place in federal court. That wasn't really a plea hearing. It was a hearing that was called by Judge Reed to explain to the defendant that she was not inclined to accept the plea agreement that he had reached, and explained all her reasons, therefore, that she was not inclined to accept that. If you look at the transcript, Judge Reed talks about the whole hearing, and Mr. Allison says two words. And that was in response to Judge Reed saying that Mr. Nathan, his attorney at the time, cared about his clients. And Mr. Allison said, I agree. Now, the jump the defense wants you to make today is that based on what Judge Reed said, and the defendant saying, I agree that my client cares about, or my attorney cares about his clients, that he committed a dastardly act of perjury during this trial that the state was required to correct. Now, there's just a lot of nuances in that. There's a lot of speculation. There's a lot of conjecture that he even told a lie, but even more so that it should be something that the state should have to address. So we don't believe that the evidence showed that Mr. Allison told a lie. Based on what Judge Reed said during the hearing, I think it can be reasonably construed by anybody, sophisticated or novice in the federal system, that it was pretty clear that Judge Reed was rejecting the plea, that she didn't want him to take the plea, and that she could give him a more harsher sentence if he went through with the plea and decided to do that, which are all things that are consistent with what Mr. Allison attempted to explain from a civilian standpoint at the trial. So I think I went into a lot of detail there, but I think that shows that just how complicated that is to make the jump that this was an obvious falsehood, if a falsehood at all, that the state should have to report. So what really, the question that's really being begged here, though, is that the credibility of Mr. Allison would be at stake as a witness, primarily if he had a plea agreement in consideration of his testimony against Mr. Burns. And there's no dispute in the record that he had no plea agreement in consideration for his testimony. Anything that's implicit, the law says, based upon what was cited in the state's brief, the law says that just goes to his credibility if there's some implicit suggestion. Mr. Spees took ample amount of time with, was a very effective cross-examination of Mr. Allison regarding his motives. There was no mystery left for the jury as to what motives, if any, Mr. Allison would have to testify against Mr. Burns. So this dispute, so to speak, over whether Mr. Allison said something false at the hearing was not germane to his motive to testify because he didn't have a plea agreement. It was not germane to his credibility at all, we contend, but at a minimum, it wasn't germane to his credibility such that it would affect the defense's strategy and would lead likely or probably to a different outcome at trial. It just wasn't significant enough to reach that standard. So for that reason and the reasons set forth in our brief, we contend that there was no falsehood, and even if there was no duty for the prosecution to report it. And finally, that even if there was a falsehood and there was a duty, it wasn't material enough to affect the outcome of the proceedings. Third, the newly discovered evidence claim. The state took a lot of time in its brief in response to address this. I think the court's well aware of the standard. Our argument starts on page 21 of our brief. And essentially what we're focusing on here is that the defense cannot establish that this newly discovered evidence is material to the case, or that the evidence probably would have changed the result of the trial. Judge, the materiality test requires that there's a reasonable probability there would have been a different result at trial. And the defense can't show this in this case. If Ms. Berkey would have been allowed to testify, the jury would have heard that in her words contained in the affidavit that Michelle Martinko had a music lesson or an organ lesson, at Westdale Mall, that she believed it was the night of Michelle Martinko's murder, that she was dressed up and she had come from a musical banquet, both of which were very public information that I think most people in Cedar Rapids know by now, in that she may have had someone waiting for her, and we don't know whether that person was someone she knew or a stranger, and that she should, her words, have had 2 organ books with her at the time she left. This focus on the organ books, I think, is a red herring, Your Honor, because Ms. Martinko was found in her car. The evidence showed that there was very little doubt that she was killed in her car, and her purse was found in there too. The state fails to follow the logic that somehow, given those circumstances, that a couple of missing music books would have been a bombshell that would have changed the outcome of this case. It quite frankly wouldn't have, and the logic doesn't make sense to reach that point. I think that the jury would also have to believe that for some reason this information evaded law enforcement for 40 years, even though this investigation had gone on for 4 decades and involved multiple witnesses, multiple false leads, some of that came out at trial, and multiple statements given to law enforcement that just didn't pan out. And I think Ms. Burke's information would have fallen in that category had it actually come forward. Because as we indicated in our brief, there was no information in the investigative file to corroborate any of what Ms. Burks has to say in this case. The jury would have to believe that all of Michelle Martinko's acquaintances that night didn't see her with organ books. She didn't mention going to a lesson, and they didn't see her at a lesson, including Mr. Thomas, who was the last one to bid her goodbye from the mall that night, had nothing to report in that regard. But more importantly, Your Honor, this would have been something that Ms. Martinko's parents most certainly would have reported and would have resulted in an interview. So the believability or credibility of this evidence is in question for those reasons, and also for the reason that our just very brief investigation and over the last 24 hours showed that not only was she not even taking organ lessons at that time, according to her family, she didn't have an organ at her house, and there was no Carmel Lou's House of Music even at Westdale Mall, where these lessons supposedly took place. So to say that had this evidence been brought up, it would have somehow rebutted or overcome the immense amount of evidence of the defendant's guilt is a stretch, Your Honor. It certainly would not have had reasonably led to any kind of different outcome at trial. If it came up, it would have been, we submit to you, dealt with amongst the rest of the evidence and had no major weight whatsoever to it. So with that being said, Judge, with regard to the evidence, the argument the defense makes that the jury's verdict was not contrary to the weight of the evidence. Beginning on page 3, we cited a case law that sets forth the court standard, which I'm sure the court is very well aware of, that only in extraordinary cases where the evidence preponderates heavily against the verdict rendered should the court reach a determination that the verdict was contrary to the evidence. In making his argument, the defendant essentially reasserts claims that were made at trial that were either ultimately conceded by the defendant during the trial or were clearly such that, in the words of the courts involved that have reviewed this standard, may present an alternative explanation or an explanation that could be one that could be weighed, but certainly not one that preponderates heavily against the rest of the evidence in the case. So we believe that being said, that there was ample evidence of the defendant's guilt, and certainly the defendant has not reached the standard by merely reasserting arguments at trial that there was evidence that preponderates heavily against the verdict. So we're asking the court to deny not only the defense motion for new trial on these grounds, but all the grounds asserted in his motion.
Thank you, Mr. Maynick. Mr. Spies, additional arguments?
Yes, briefly, Your Honor, thank you. Again, concerning the testimony that was elicited during the testimony of Paul Bush, the government says it should come as no surprise that they would denominate the evidence of the location of some of Mr. Burns's DNA as blood. Yeah, it certainly was no surprise, but it was a fighting issue during the course of the trial whether or not the DNA that was extracted from Ms. Martinko's dress or from the gear shift came from blood or whether it came from some other biologic source. And again, I don't think it was posited as a hypothetical. I objected on foundation grounds. The court, I think, agreed that it was a mischaracterization and admonished the jury through a curative instruction. But again, for all the reasons, given the weight of the fact that this was coming during rebuttal testimony to refute the scientific testimony from Dr. Spence, I think caused it to carry undue weight under the circumstances, and that the curative instruction was not sufficient to undo the damage, with all due respect to the court. Concerning Mr. Allison's testimony that he didn't really lie, well, he did. And to say that Judge Reed was not inclined to accept the plea agreement is not the fact. She said explicitly, I rejected the plea agreement flat out. She also said to Mr. Allison, at this point, there is no plea, period. And for Mr. Allison to testify in a manner that kind of skimmed the facts or shaved the truth, either way you put it, he was lying. And those lies were material. They went explicitly to his credibility as a witness on someone who was the only witness who was able to say that Mr. Burns allegedly implicated himself in the murder of Michelle Martinko. Concerning the new evidence, the government again alleges that it wasn't material, that it was. The fact that the witness, Ms. Berkey, had a specific recollection about the number of books that Michelle Martinko would have taken to her during her lesson was pretty graphic of her recall. Also, her being surprised that she had never been questioned about Ms. Martinko by law enforcement. And the reason this is all important is because it demonstrates that Ms. Martinko had a routine, and that routine would have been something that someone familiar with her would know. We know from the manner in which the wounds were inflicted that these were intended to disfigure, that they were personal, and all the more of an indication that someone who knew her whereabouts, knew her routine, knew where to find her, had a reason to kill her, not someone who would drive from an hour away on a night when there was no reason that he would expect to find her or anyone else to inflict fatal wounds. Makes it all the more material. Again, Your Honor, we think for all those reasons, and either individually or cumulatively, warrant your deciding today that Mr. Burns is entitled to a new trial, unimpeded by the errors that were made during the course of the trial and unimpeded by the falsity that was injected into this trial.
Thank you, Mr. Steves. Anything further on behalf of the state with regard to the motion for new trial?
No, Your Honor.
Okay. Again, in the interest of making sure that our record is clear, under the rules of criminal procedure, the motion for new trial, the first one was filed on May 29 of 2020. There was some consultation between counsel and the court regarding the requirement of the rules of procedure that that motion be heard within 30 days of its filing. We had some discussion by way of email. Both sides, the defense and the state, filed documentation with the court indicating they felt that given the COVID-19 pandemic that there was good cause. I did make a specific finding that we would hear that motion at a later time. I just want to make sure that that is very clear in our record, that today's hearing is taking place in the manner that it is because of the COVID-19 pandemic, and the timing of this hearing is because of the concerns with the COVID-19, and that I find that we are hearing this in a timely fashion and that there won't be any prejudice due to the timing of today's hearing. The court will go through paragraph by paragraph the motion for new trial that was filed by Jerry Lynn Burns, the first of which was filed on May 29 of 2020. Beginning with paragraph number 3, Mr. Burns asks the court to grant a new trial given the court's ruling on motions to suppress that included suppressing, he asked the court to suppress evidence that was seized not only from his person, but from the persons of family members of Mr. Burns. He went on to ask the court to grant a new trial, given the fact that the court did not grant the motion to suppress either the physical evidence or his statements made to law enforcement on December 19 of 2018. And the court will stand on the written ruling as well as the statements that were made on the record at the motion to suppress. That motion was lengthy and detailed, and the court entered a written ruling overruling Mr. Burns' motions, and the court will stand on the record on the motion to suppress and overrule the motion for new trial on that ground. In paragraph number 4 of the May 29, 2019 motion for new trial, Mr. Burns asks the court to grant a new trial in light of the court's overruling his motions for judgment of acquittal at the close of the prosecution's case, and again at the close of the evidence at trial. The court will again rely on the rulings made in open court and on the record with regard to each of those motions that the court did overrule and deny. And the motion for new trial based on those grounds, overruling the motions for judgment of acquittal, will be overruled and denied. Mr. Burns goes on in paragraph number 5 to urge the court to find that the jury's verdict was contrary to the weight of the evidence. This is the the standard for the court to consider when hearing a motion for new trial is to make a determination whether the verdict is contrary to the weight of the evidence or contrary to the law. I will make a finding at this time and again at the conclusion of my comments on this regarding my view of the weight of the evidence and specifically with regard to paragraph number 5, I find that there has not been a miscarriage of justice and that the weight of the evidence supports the jury's verdict in this case. In paragraph number 6 of the May 29 filing, Mr. Burns urges the court to grant a new trial based on the fact that the court overruled a challenge pursuant to Batson versus Kentucky with regard to strikes made by the state in jury selection. The court will again, my recollection is that we had a lengthy discussion. There was a detailed record in the course of jury selection, and the court made a detailed ruling on the record in the process of the jury selection, and the court will rely on that record in overruling the motion for new trial on that ground. With regard to the motion for mistrial in Paul Bush's testimony during the state's rebuttal case, the court redirected Mr. Maybanks to rephrase the question, excluding the specific word blood. That question was rephrased and put again to Mr. Bush, and the court admonished the jury, and the court will again stand on the record that is contained in the trial transcript with regard to that motion for mistrial, and that ground for in the motion for a new trial will also be overruled and denied. With regard to the testimony from Michael Allison, Mr. Allison was certainly subjected to a vigorous and thorough cross-examination by Mr. Spies on behalf of Mr. Burns. The court is not persuaded at this point. I have reviewed the transcript from the what struck me as a slightly unusual hearing that the court called in order specifically to have a conversation with Mr. Allison about the court's reason for refusing to proceed with the plea agreement. But I did review that transcript, and by my notes in the trial, Mr. Allison, I would agree, Mr. Allison either didn't understand exactly what was happening, or he wanted to believe that the judge was somehow on his side. However, I have reviewed my notes from the trial, and Mr. Allison was certainly put through his paces, and Mr. Spies conducted a very thorough and vigorous cross-examination of Mr. Allison, and I believe that there wouldn't have been any question about Mr. Allison's truth or veracity at the conclusion of that cross-examination. In paragraph number 9, paragraphs 9, 10, and 11, Mr. Burns raises error or asserts that the court erred in overruling his requests for certain jury instructions. The court and counsel conducted a lengthy informal conference regarding jury instructions. We then had a lengthy on-record discussion regarding proposed instructions, and then the court conducted, again, on the record, a formal ruling regarding which instructions would be submitted to the jurors, and the court will again stand on the findings made and the determinations made in the course of the trial And the grounds raised in paragraphs 8, 9, and 10 in the May 29, 2020 motion for new trial, 9, 10, and 11 will be overruled for the reasons stated in the instruction conference that took place during the trial in February. With regard to the claim that there has been newly discovered evidence, as the parties are aware, if a defendant seeks a new trial based on newly discovered evidence, the defendant must show that the evidence was discovered after the verdict, that box has been checked. The defendant must also show that the evidence could not have been discovered earlier in the exercise of due diligence. The record at this point has no indication that evidence couldn't have been discovered in a timely fashion in the exercise of due diligence. The defendant must then go on to show that the evidence is material and not merely cumulative or impeaching, and that the evidence probably would have changed the result of the trial. And based on the record before the court today, as I stated, there has been no showing that this evidence could have been discovered earlier through the exercise of due diligence. And I am not persuaded that the testimony, if it had been presented in the manner in which it is shown to us by way of affidavit, that it would have probably changed the result of the trial. So for those reasons, at this time, the court will overrule and deny the motion for new trial and the supplemental motion for new trial. And at this time, if there are no other legal causes to prevent us from proceeding to sentencing, we will proceed to sentencing. Do you know of any other legal cause, Mr. Spies, that we cannot proceed to sentencing?
Only one matter that I'd like to address to the court, Your Honor. That is in filing the memorandum in support of our motion for new trial, there were 3 attachments, post-trial exhibits A, B, and C, and I would formally offer those into evidence. Even though they've been filed, I would ask that they be received as evidence in support of the motion.
Mr. Maybanks or Mr. Harris, do you have any objection? Defendant's post-trial exhibit C that was attached to the August 5th memorandum in support of the motion for new trial is an email exchange between Mr. Spies and, I'm probably going to get the name wrong, Sean Wady?
I think it's just Wade. Yeah.
From the U.S. Attorney's Office. Defendant's B is, I believe, the transcript of the colloquy or the record made by Judge Reed in the United States District Court on January 15 of 2020. And Exhibit A is the affidavit of Terry Klooster. I assume that the state has had an opportunity to review those proposed exhibits.
Yes, Your Honor.
Objection to the court receiving those and formally making them part of the sentencing or the hearing on the motion for new trial.
No, Your Honor.
The court will receive those defendants' exhibits A, B, and C and make them part of the record this afternoon. Any other legal cause why we cannot proceed with sentencing at this point, Mr. Spies?
No, Your Honor.
Okay. And Mr. Maybanks, do you know of any legal cause the court cannot proceed to sentencing in light of the ruling on the motion for new trial?
No, Your Honor.
Mr. Maybanks, does the state have comments regarding a sentencing at this time?
Yes, Your Honor. Your Honor, the verdict in the sentence now that you are about to impose, the state believes will give closure and peace to the family and the many friends of Michelle Martinko that have longed for justice for her for 4 decades. and it also will provide enormous relief for our community. A parent's worst fear is sending their child out into the world and having that child never come back to them. And this is the fear that was impaled in the hearts of mothers and fathers across this community for decades. To add to the misery Michelle's parents suffered, they had to live with the fact that she was brutally and senselessly murdered. I don't think we'll ever be able to appreciate what her parents went through. And nobody should have to endure that pain. And although we lost Michelle 40 years ago, it's obvious that pain is still very real for a lot of people in this community. We saw her picture and her photo during the trial, and it's clear that just looking at her, in all of her eyes, she'll always be 18. And that when she was 18, there was no doubt the world was hers for the taking, but that Mr. Burns took her from the world. So we'll probably likely never know why he did it, which is also tragic, because this is the type of crime that's so heinous and senseless that it's an assault not only on Miss Martinko, but on our very human nature. This is the type of crime that would makes us all collectively ask why. Why did it have to happen? Even though we know that there's no answer to that would ever be acceptable. So we're asking the court to impose today the mandatory sentence in this case of life in prison without the possibility of parole, and also to impose the required restitution to the victim's family. Mr. Burns will have the rest of his life to ask for forgiveness and beg for mercy, but even if he doesn't, we believe that as a result of this trial and the sentence today, at least he won't be able to block it out anymore. Because this moment has finally came for the community and for Mr. Burns. Today is his moment of reckoning, but today, it's also the moment of the long-awaited resting in peace for Michelle. With that, we just ask that justice be served, Your Honor.
Thank you, Mr. Maybanks. Mr. Spies, your comments regarding sentencing on behalf of Mr. Burns.
Your Honor, as we made clear at the outset of Mr. Burns' trial and throughout, there is no one that has anything but sympathy and heartbreak for the Martinko family. There is no criticism of the effort that was been made by law enforcement to see justice done in her case. But we believe that the justice that was given to Mr. Burns was misdirected. There's another family in this courtroom today whose lives have been changed, Mr. Burns' family, who remain resolute, supportive, committed in his innocence. It's our hope that the justice system that brings us here today will in time bring him back for a new trial, uninfected by the errors that we've alleged in the motion for new trial. We know that the court has no discretion in imposing sentence here today. We only hope that another day will come where Mr. Burns will receive through justice the not guilty verdict that he's entitled to.
Thank you, Mr. Spies. Mr. Burns, we have reached the stage in this sentencing hearing where, pursuant to the rules of criminal procedure, you have the right to address me with any facts or circumstances you think are important and that I should consider before I enter judgment and sentence you today. This isn't to put you on the spot or make you nervous, but pursuant to the rules, if you have anything to say, sir, this is your opportunity to speak.
Thank you, Your Honor. First of all, I'd like to say that somebody else stabbed Michelle to death in that car that night. I don't know who, I don't know why. But I would like to thank my family and friends for their support. Thank you.
Thank you, Mr. Burns. It's my understanding that Michelle Martinko's sister and brother-in-law have prepared a statement that they would like me to hear. Is that correct, Mr. Maybanks?
It is, Your Honor, and we have a pre-recorded video statement of that. It's going to be broadcast here on this TV.
Judge, where would you like the TV played?
Probably it's going to be easier for me to relocate. I will step down and you can have it right up there. Mr. Harris, before you begin that recording, I just want to remind everyone, because this is a recorded statement, I'm not going to require Ms. Thomason to take that down, so I would ask everyone to please be quiet. We'll all listen to the recording, and then we will resume the record when I'm back on the bench.
My name is John Stonebreaker. I'm Janelle Martinko Stonebreaker's husband. Our family spent 39 Christmases under a shadow without answers, a shadow that never left. 39 Christmases. The court can well imagine the shock, anguish, and horror we felt on learning of Michelle's awful death. I'll never forget Michelle's mother, Janet, calling in the early morning hours of December 20th, 1979. She wasn't crying so much as gasping, choking. She could hardly speak. That night she had identified the body of her bloody, torn, broken daughter, her beautiful daughter, her miracle baby born to her at age 44. She faced with strength the terrible tasks of first identifying Michelle's mutilated body, and then calling us in Davenport, but with the most grief-stricken anguish I had ever heard or ever expect to hear. I don't remember much of that day now. What I remember most are the 39 Christmases with our little family, diminished by one, and everyone's brave efforts to be merry and normal, mostly for our boys, Michelle's nephews, year after year. And that year, 1979, Michelle's presents were unopened. Families experience the sudden loss of a loved one every day. Car accidents, heart attacks, 100 other things shattered normal lives in an instant. We understand that, and to that extent, we're no different. What is an order of magnitude worse is the viciousness with which Michelle was taken, and the terrible questions that were never far from our minds, the who and the why. How could anyone hate so much? Someone who did not even know his victim. For us, the answer lies not in hatred. The post-arrest investigation provides the answer. For us now, the answer lies in a deeply selfish, lifelong personal need. A need Mr. Burns kept hidden all his adult life until now. As time passed without an arrest, Janet Martinko became bitter and withdrawn, and pretty much stayed that way. She directed her anger at an old boyfriend of Michelle's, whose DNA proved him innocent. But his innocence seemed to trouble her and confuse her even more. Al, Michelle's father, was more stoic, He suffered more privately. One of his co-workers at Smolikov's department store said that Al would sometimes just sit at his bench where he repaired watches and silently weep. Before Michelle's death, I'd ask, "How you doing, Al?" He'd always answer, "Mighty fine, mighty fine." I don't remember him saying that afterwards. This court, as an instrument of the law, will soon punish Mr. Burns for taking Michelle's life. But the law cannot punish him for the damage done to her family and loved ones. The law cannot punish him for the terrible shock, shame, pain, and devastation in the innocent lives of the killer's own family and his loved ones. As we have done, they will pick up the pieces of their lives, mend them, and go on. We are sad for them. We reach out to them in their sorrow and ours, and wish them well. We deeply regret that Michelle's dad and mom aren't here to know what their surviving daughter knows. That is Mr. Burns, who took Michelle's life, and will forfeit his freedom forever. It helps to know that his world will be a sad little cell, and that Mr. Burns will never again smell the rich, freshly plowed earth of Delaware County, or the new mown hay in the summer. The sights, sounds, and enrollments of his world will be very different. Many inmates put a calendar on their wall. They literally mark time putting an X through each day that passes, because they have a goal: freedom. And as their goal gets closer every day, their hope develops. There's satisfaction in making that X every day. Optimism, hope, a future. But Mr. Burns won't do that. He has no hope. He will die alone. Mr. Burns will be given pain medication if he needs it, in a humane gesture to ease his transition from light to darkness. Mr. Burns may receive a sedative to calm him for what lies ahead. His mark on the world and the sum of his life will be a short notice saying, "Convicted murderer dies in prison. Convicted Martinko murderer dies in prison." Of course, Michelle got no pain medication. She received no sedation to dull the terrible horror, confusion, pain, and panic of what was happening. Just 6 days before Christmas, she died alone. Instead of a loving family at her side, the last face she saw was Jerry Lynn Burns, and it tears our heart out. Judge Hoover, Janelle and I are thankful in another way. We're thankful that she fought so hard. Michelle played a critical role in identifying her own killer. The defensive wounds on her hand show it. She fought so hard that she was able to deflect the killer's knife so that he stabbed himself, leaving the blood that caught him. In a very real way, Michelle became her own best witness. Still, Mr. Jerry Burns was clever enough to steal 39 years of freedom he didn't deserve, and he knows it. And without a hint of shame, he said as much. And in another sense, in the most selfish act a human being is capable of, he stole those 39 years and many more from a sweet, smart, talented girl who never got her chance at college, a career, marriage, children, and by now even grandchildren. While Mr. Burns has been living free without the conscience of a real man, what remains of Michelle rests with Janet and Al Martinko in Cedar Memorial. Your Honor, thanks to the humanity, wisdom, and mercy of the people of Iowa, Mr. Burns cannot be put to death for what he did. We are at peace with that. he receives a grant of mercy from the faceless state of Iowa that Michelle did not. But he will die a little bit every day and in his long nights to come. And there's some justice in that. Mr. Burns went to Westdale Mall to kill. Armed with a knife and rubber gloves that he was sure would protect his identity, he picked Michelle out of the crowd of Christmas shoppers that night, stalked her, and killed her. Janelle and I are comforted, and we can all be comforted by the fact that if it wasn't Michelle that night, it would have been some other young woman. And that young woman is surely alive today, well into late middle age, because Michelle is not. It angered us beyond measure to learn that Mr. Burns listed among his regrets that he did not clean up after himself after the murder. He did not regret his act of killing another human being. No. He regretted not doing a better job. And his comment to his cellmate that he thought was so clever, threatening to, quote, take him to the mall if he won again at Pinochle. Beyond hurtful, of course, but in that way he described himself graphically as among the most odious of human beings. We are forever grateful to the people of Cedar Rapids for keeping hope alive for 39 years, to Cedar Rapids law enforcement for their professionalism and endless resolve to see this case through to a resolution, to the Lynn County prosecution team for their effective work, and to the support staff they provided to us. Over these many years, Cedar Rapids has never been far from our thoughts. And it has been a constant comfort to us that Michelle has meant so much to so many. Finally, Your Honor, Mr. Burns will soon board a state van and be removed from civilized society, excised from all of us like an oozing wound. We are cleansed by his absence, and the remaining members of Michelle's family and loved ones are healed by the knowledge that he will never walk free again. Thank you.
Any other impact statements on behalf of the Martinko family?
No, Your Honor.
Thank you. At the risk of repeating myself, I do want to make sure that our record is very clear that with regard to the motion for new trial filed May 29 and supplemented on August 5, 2020, that the court finds that the verdict rendered on February 24, 2020 was contrary neither to the weight of the evidence nor to the law, and that the court finds that the greater amount of the credible evidence supports the jury's verdict. At this time, a judgment will now enter upon the jury's February 24, 2020 verdict, finding Jerry Lynn Burns guilty of murder in the first degree, a Class A felony in violation of Iowa Code Sections 707.1 and 707.2 Code of Iowa. Pursuant to Iowa Code Section 902.1, Jerry Lynn Burns, you are now remanded to the Director of the Iowa Department of Corrections for the rest of your life. The Lynn County Sheriff shall transport Mr. Burns to IMCC Oakdale when there is bed space available. Mr. Burns will receive credit for each day that he spent in the Lynn County Sheriff's custody dating back to his arrest on December 19 of 2018. Pursuant to Iowa Code Section 910.38, Jerry Lynn Burns shall pay a sum of $150,000 to the estate of Michelle Martinko. In the event there is no estate opened, the payment of any monies shall be paid to the heirs of Michelle Martinko. Those heirs shall be determined pursuant to Iowa Code Section 633.210. Pursuant to Iowa Code Section 901.5, subsection 8A, Mr. Burns is ordered to submit to a DNA profile upon request, if Mr. Burns has not already done so. The reasons for the court's sentence today are short and very simple. The Iowa legislature prescribes the sentence for a Class A felony. The jury on February 24, 2020, found that the state proved beyond a reasonable doubt each element of murder in the first degree. Therefore, this is a mandatory sentence. There is no possibility of parole. Any costs that are associated with the prosecution of this matter will be assessed to Mr. Burns, in addition to any victim restitution that is later set out in a pecuniary damage statement. The court will order that if there is an additional statement of pecuniary damages, that shall be filed with the court within 30 days of today's date. Mr. Burns, you do have the right to appeal. In order to appeal, you must file a written notice of appeal with the clerk of the Lynn County Court within 30 days of today's date. If you fail to file a timely notice of appeal, the Supreme Court of Iowa will lose jurisdiction to take up any appeal you wish them to examine. As I stated earlier, there is no right to an appeal bond. Any appearance bond will now be exonerated, but Mr. Burns will be held without bond pursuant to Iowa Code Section 811.1. Anything further from the state?
No, Your Honor.
Anything further, Mr. Spees?
Only one matter, Your Honor. The court in its imposition of sentence said that costs would be assessed against Mr. Burns, and I understand this morning there was a statement filed by the clerk of court not itemizing those costs, but we will be requesting a restitution hearing in accordance with Section 910.3.
So you'll be seeking a restitution hearing?
Yes.
Okay. I couldn't hear you, sorry. All right. We will schedule a hearing on that request. If there is nothing further, we will be adjourned. Parties are excused.